senior advocate Rebecca John Mam, who will be addressing the session on the topic of criminal defamation, free speech, and the right to equality. Just to state a little about Mam was enrolled with the Bar Council of Delhi in 1988 and has been practicing in the field of criminal law since then. In 2013, Mam became the first woman to designated as a senior counsel by the High Court of Delhi on the criminal side. Mam has conducted a wide range of criminal trials and argued appeals dealing with Unlawful Activities Prevention Act, Prevention of Corruption Act, and other special statutes. Over the years, Mam has represented accused persons as well as victims. Amongst the list of cases to her credit are the Jen Hawala case from 1996, the 2G Spectrum case, the Arushi Talwar murder case, the Srishant IPL match fixing case, the Hashimpura massacre case, and so many. Mam is also a member of the Internal Complaints Committee of the Delhi High Court, dealing with complaints under the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act 2013. Mam is also a statutory member of the Delhi High Court Legal Service Committee. Ma'am, we at MNLU Mumbai are honored to have you as a speaker of the second lecture of Criminal Justice Talks. Now, without further ado, I request ma'am to take the session ahead.
Thank you very much, Utsav. And a special thanks to Mr. Anil Variath as well as Professor Uke for the kind words of introduction. I would like to thank the students and faculty of the Maharashtra National Law University, Mumbai, for inviting me for this lecture. When the invitation came to me, I was in the midst of refusing many similar invitations because if I'd accepted all those invitations, I would have been doing one lecture per day. And since our courts have opened physically, it is no longer possible for me to take these lectures. But when a university asks me to conduct a lecture, I try as far as possible to accede to that request only because I like talking to young people. And I believe a younger audience is always the best audience you can have to put your point of view across. It is far more interactive. And I, by and large, try and respond to any invitation by a law university because it's just something which is so enriching. So I couldn't really refuse you, and which is why even when I came into office today, I was told this is the last of the series and we are going back to work from Monday. So thank you very much for inviting me for this lecture. I don't necessarily follow any script in court, so I won't be following any particular script in this lecture as well. So that one can be enriched both with respect to aspects of criminal law, the law of defamation, and of course its interconnection with free speech. Freedom of speech and expression is critical and intrinsic to a democratic society. The offense of criminal defamation is a limited fetter on the right to freedom of speech and expression under 19(1)(a), being one of the reasonable restrictions under 19(2). This right is therefore not unrestricted, but the court, while adjudicating on a restriction of this right, must consider the beneficial interest in letting speech persist and the chilling impact of restricting the freedom of speech and expression. Any prosecution for defamation is a direct curb of this fundamental right. Every great scandal is unearthed because one person shows the courage to expose it to the public for public good and in public interest. Can the court and the justice system be manipulated through the offense of defamation to protect the powerful and curb legitimate speech? Does the balance of interest of fundamental right of free speech vis-a-vis reasonable restriction lie with silencing victims or empowering them? Can women reporting sexual harassment at the workplace and newspapers reporting on these allegations be silenced? Can criminal defamation law be weaponized to destroy matters of public interest and public good? Before I go further, I'd like to talk about what exactly is criminal defamation. Section 499 of the Indian Penal Code defines criminal defamation. The basic definition of this section is predicated on the fact that words are spoken either to be read or to be seen. It is made or published. And these words are in the nature of an imputation. Imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of that person. So intrinsic in this section are 2 or 3 essential ingredients. 1, whoever by words intended to be read publishes any imputation concerning any person. 2, there is an intention to harm, or at least there is a reasonable belief that such imputation will harm. 3, the reputation of such person. Now, obviously, if these ingredients are satisfied, then a person may invoke Section 499 of the Indian Penal Code and file a case for defamation, for criminal defamation against the person who has made such imputation. Now, because most of you are part of a criminal law course, it is important, and I will use this opportunity to explain the structure of these cases within the statutory framework within which they operate. Defamation is a non-cognizable offense. It is a bailable offense. Defamation is triable. The case of criminal defamation is triable as a summons case. Now, as you know, the Code of Criminal Procedure has different types of cases: summons cases and warrants cases. Largely speaking, summons cases are those cases where the maximum term of imprisonment does not exceed 2 years. Warrant cases are those cases where the term of imprisonment exceeds 2 years. Now, within warrants cases, you have warrant cases that are triable on the basis of a police report, and you have warrant cases which are triable otherwise than on a police report. What is then defamation? Which category does a criminal defamation case come within? Now, if you were to read Section 199 of the CRPC, it says that no court shall take cognizance of an offense punishable under Chapter 21 of the Indian Penal Code, which is the chapter relating to defamation, except upon a complaint made by some person aggrieved of the offense. So one of the essential prerequisites to initiating proceedings under Section 499 is that the complaint case procedure must be followed and not the state case procedure. So no FIR will lie for an offense under 499. What needs to be done is to file a private complaint before a court of the magistrate. That complaint will be taken cognizance of by the magistrate under Section 191A, and then it proceeds to recording the statement of the complainant and his supporting witnesses under Section 200 of the Code of Criminal Procedure. Thereafter, if the magistrate finds that no offense is made out, the magistrate can dismiss the complaint under 204 of the CRPC, or if the magistrate is of the opinion that there are grounds to proceed further, that a prima facie case has been made out, then the magistrate will proceed to issue summons under Section 204 of the Code of Criminal Procedure. Now, since it's clear that defamation is a summons case, is an offense for which the summons case procedure can be invoked only on a complaint, what is the step forward? As soon as a complaint is filed, pre-summoning evidence of the complainant and his witnesses are recorded, and summons are then issued based on the veracity of the pre-summoning evidence and the complaint. However, if you were to look at Section 499 very closely, Section 499 has a set of explanations as well as a set of exceptions. And most people are unfamiliar with them. 499 has four explanations. One, the first explanation is that it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living and is intended to be hurtful to the feelings of his family or other relatives. It may amount to defamation to make an imputation concerning a company or an association or collection of persons. That's explanation 2. Explanation 3 says an imputation in the form of an alternative or expressed ironically may amount to defamation. And lastly, and this is an important explanation, no imputation is said to harm a person's reputation unless the imputation directly or indirectly in the estimation of others was the low moral or intellectual character of that person. So when we challenge criminal defamation proceedings, one of the things that we always look into is whether explanation 4 has been satisfied or not. It is not enough for me to say that I have been defamed. It is important for me to establish that I have been defamed in the estimation of others. And that can only be done if I produce supporting witnesses who say that the imputation resulted in the lowering of my reputation in their estimation. So this is how the offense of defamation is complete. Now, once the offense of defamation has been prima facie established and an accused is summoned under 204, then the magistrate will straightaway follow the procedure given under sections 251 onwards, which is the summons case procedure. So as soon as the accused appears before the court, the very first time the accused appears before court, the magistrate will frame a notice under section 251 of the Code of Criminal Procedure, which is akin to charges that are framed in more serious offenses under warrant cases as well as sessions tribal cases. Essentially, the substance of the accusation is read out to the accused person, and the accused person is asked whether or not he pleads guilty to the offense. Now, here again, there is an interesting difference between 251 and charges. If you were to look at 251 of the Code of Criminal Procedure, not only is an accused asked whether he pleads not guilty or guilty to the charges, but is also asked whether he has a defense to lead. So it's a twin obligation that has to be fulfilled by the magistrate at the time when he is putting forward the notice to an accused person. He must ask whether or not he pleads guilty, whether or not the accused pleads guilty or not guilty to the offense, and must proceed to ask whether the accused has a defense to make. And both these must be answered with a certain degree of robustness by the accused person if he has a robust contestation to make. I will come to these sections later in the context of the Priya Ramani trial, which I will discuss in some detail. Now, after a notice has been framed and the accused pleads not guilty and the accused claims trial and the accused says whether or not he has a defense to make, the next step is the recording of post-summoning evidence, where the complainant and his attesting and his character witnesses will once again come to court, and they get to be cross-examined by the other side, in this case by the accused persons. Once that is over, there is a statement under 313 where all the incriminating circumstances are put to an accused person. The accused responds to those 313 questions, and then there is, of course, defense evidence if the accused wants to plead any specific defense. Now, coming to the Ramani trial. Priya Ramani was prosecuted for 3 tweets and an article she had written at the height of the Me Too movement in India in 2018. As you are aware, the Me Too movement began in America in 2017, and Many disclosures were made against film producer and director Harvey Weinstein. There were many articles written in the context of the Harvey Weinstein complaints, and some prosecutions also took place. The movement moved to several other countries. In 2018, October 2018, it came to India. And many women took to social media platforms, including Twitter, to call out their male bosses. Some of the incidents were of decades ago. Priya Ramani, in 3 tweets published on the 8th of October, 10th of October, and 14th of October 2018, called out her male boss with relation to the first interview she had with her male boss sometime in December 1993. She had previously written an article for the Vogue magazine in 2017, where she was asked to talk about the Harvey Weinsteins of the world. And in that context, she had devoted a part of the article to her own personal experience with her first male boss. She had not taken the name of the male boss at that time. She had anonymized it. But in 2018, when she called out her male boss in her first tweet, which was published on 8th of October 2018, she attached a link to that Vogue article and called out her male boss. The cloak of anonymity was removed and the name was published. Based on these 3 tweets and the article, Priya Ramani was prosecuted for criminal defamation. A criminal complaint was filed in the court of a metropolitan magistrate in Delhi. Pre-summoning evidence was led. The accused was summoned. Post-summoning, Priya Ramani appeared in court. And on the very first occasion, she was read out a notice where the court, and I'll read it, amongst other things, said that you intentionally made and published the aforesaid articles and tweets, thereby lowering the reputation of the complainant in the estimation of right-thinking members of the public, his friends, his colleagues, his peers, his professional and political fraternity, and committed the offense of defamation punishable under Section 500 of the Indian Penal Code, and I hereby direct that you be charged for the above offense. Thereafter, it has been noted, the notice has been read over and explained to the accused and questioned as under. Have you understood the notice as framed here and above? Yes. Do you plead guilty for the aforesaid offense? Answer, I plead not guilty and claim trial. Question, do you have any defense to make? Yes, I have a defense to make. I plead truth as my defense, made in good faith, in public interest, and for public good. I will prove my defense during trial. The reason I read this out to you is because not only was she obligated under 251 to state what her defense was, but she has also specifically taken the statutory defenses available to her under Section 499 of the Indian Penal Code. When I read out the definition of 499, I did not read out the 10 exceptions that are part of 499. And these are statutory exceptions. If you were to read these 10 exceptions, you will know that these offer a complete defense to defamation if proved. Now, what are these exceptions? Priya Ramani pleaded the first, third, and ninth exception. Let me just quickly read these exceptions out to you. The first exception is imputation of truth which public good requires to be made or published. It is not defamation to impute anything which is true concerning any person if it be for public good that the imputation should be made or published. What are the ingredients of the first exception? The first exception recognizes that the imputation is not defamation if what you are saying is the truth, made for the public good, and whether or not it is public good is a question of fact. So Priya Ramani pleaded the first exception. She also pleaded the ninth exception, which is, it is not defamation to make an imputation on the character of another provided that the imputation be made in good faith for the protection of the interests of the person making it or for any other person or for public good. Again, what is important in the ninth exception is good faith and public good. Interlinked with the first and the ninth exception is exception 3. Exception 3 says it is not defamation to express in good faith any opinion whatever respecting the conduct of any person, touching any public question, and respecting his character so far as his character appears in that conduct and no further. Therefore, when Priya Ramani, in her response to the notice, when asked, you have a defense to make, when she said, yes, I have a defense to make, I plead truth as my defense, made in good faith, in public interest, and for public good. What she was doing, in effect, was pleading the first, ninth, and third exception, the one of 3 of 10 statutory exceptions which are provided for under section 499 of the Indian Penal Code. So, once you plead these exceptions and you say you will prove these exceptions during trial, what happens? Now, if you were to read section 105 of the Indian Evidence Act, section 105 of the Indian Evidence Act says that when a person is accused of an offense, the burden of proving the existence of circumstances, bringing the case within any of the general exceptions in the IPC, or within any special exception or proviso contained in any other part of the code, or in any law defining the offense, is upon him, and the court shall presume the absence of such circumstances. The minute you plead any general exception, or what are general exceptions? General exceptions are contained in Chapter 4 of the Indian Penal Code, Section 76 onwards of the IPC. Insanity. This is a general exception. Now, there are specific exceptions. Specific exceptions like the one that I read out under Section 499 of the Indian Penal Code. So 105 of the Indian Evidence Act says that when you plead a general exception or a specific exception, the onus shifts on you. Since you have pleaded that exception, the onus shifts on you to prove that exception. How is this relevant? In the context of criminal law, this is relevant because ordinarily, only the prosecuting side or the complaining side is burdened with the onus of proving its case beyond reasonable doubt. However, 105 says that when you plead an exception, the onus shifts to the side pleading the exception. So does the defense who is pleading one of these exceptions have to prove its defense beyond reasonable doubt? That's an interesting question. And during final arguments, I submitted to the court, based on law passed by the Supreme Court, that the defense does not have to prove its case beyond reasonable doubt, although 105 shifts the onus onto the defense. Because the standard of proof on a person pleading a general or a specific exception is one of preponderance of probability and not proof beyond reasonable doubt. The prosecuting agency alone is burdened with crossing the threshold of proof beyond reasonable doubt. Even if an accused proves a general or a statutory exception, and even with the burden of 105 on the accused person, the standard of proof, according to the Supreme Court, is not proof beyond reasonable doubt, but only preponderance of probability. And the Supreme Court, in several judgments, has laid down this law. In a Constitution Bench judgment of the Supreme Court called Harbhajan Singh versus State of Punjab, AIR 1967 Supreme Court, page 97, the Supreme Court has said, and I quote, "It is true that under Section 105 of the Evidence Act, if an accused person claims the benefit of exceptions, the burden of proving his plea that his case falls under the exceptions is on the accused. But the question which often arises and has been frequently considered by judicial decisions is whether the nature and extent of the onus of proof who claims the benefit of an exception is exactly the same as the nature and extent of the onus placed on the prosecution in a criminal case. And there is consensus of judicial opinion in favor of the view that where the burden of an issue lies upon the accused, he is not required to discharge that burden by leading evidence to prove his case beyond reasonable doubt. That, no doubt, is the test prescribed while deciding whether the prosecution has discharged its onus to prove the guilt of the accused. But that is not a test which can be applied to an accused person who seeks to prove substantially his claim that his case falls under an exception. Where an accused person is called upon to prove that his case falls under an exception, law treats the onus as discharged if the accused person succeeds in proving a preponderance of probability. As soon as the preponderance of probability is proved, the burden shifts to the prosecution, which has still to discharge its original onus. This is the stated position in law, that even when you plead exceptions, and notwithstanding the presence of Section 105 of the Indian Evidence Act, the law says that the burden on an accused person is only to cross the threshold of preponderance of probability. Proof beyond reasonable doubt has to be fulfilled by the prosecuting side. Several other judgments of the Supreme Court have reiterated this position. This includes the judgment of the Supreme Court in Jeffrey Dyemeyer versus State of West Bengal, 2010, Volume 6, SCC 243, K.M. Nanavati versus State of Maharashtra, AIR 1962, Supreme Court 605. This was a case where was pleaded. Now, in the Ramani case, therefore, once she pleaded these exceptions, she was required to prove those exceptions under 105. But as I said, that proof was only to cross, she was only expected to cross the test of preponderance of probability and not proof beyond reasonable doubt. Now, how do you do so? One, we exercise the right of cross-examining the complaining witnesses, the complainant himself and his supporting witnesses. In answer to several questions under Section 313, Ramani pleaded truth as her defense by giving details of the incident that took place between her and the complainant in a hotel room in December 1993. But it didn't end there. Under Section 315 of the Code of Criminal Procedure, an accused can come as a witness in her own defense. Priya Ramani exercised that right and appeared as a witness in her own defense as defense witness number 1, where she gave details of the incident that took place in the hotel room. She also talked of the corroborative material that she was about to produce. And in this manner, she testified on oath as a witness, subjected to herself to cross-examination, and therefore offered a degree of proof which an accused person otherwise is unable to produce. She offered 2 more witnesses who came in her support. Defense witness number 2 was a friend of hers to whom she had confided about the incident in 1993. She was with her immediately preceding the incident, and she was thereafter called late at night on the phone by Priya Ramani to disclose what had happened to her in that hotel room. Now, it can be said that this kind of corroboration is an afterthought. After all, who is to test whether or not such a disclosure was made to a close friend in 1993? However, Priya Ramani and defense witness number 2 were blessed with another form of corroborative evidence. As soon as Priya Ramani tweeted on 18th of October 2018 about the incident and named her male boss responsible for the incident, a few hours later, defense witness number 2 sent Priya Ramani a message on WhatsApp. Now, this was at least 10 days before a complaint was filed against Priya Ramani, and therefore can't be treated as some kind of an afterthought. And this lady messaged Priya and said, "Oh my God, I remember this incident. I was with you, and I remember you calling me up. I was wondering whether you would call out your male boss, and I'm so happy that you did." This WhatsApp message was exhibited in original, both by Priya Ramani as well as defense witness number 2. Their phones were verified by the court, and an original exhibit number was given to this message, received by Priya Ramani and sent out to Priya Ramani by defense witness number 2. So we had corroboration of a very, very high order. However, I have also said that one of the essential ingredients of defamation is reputation, because the imputation made must have the potential of harming a person's reputation. And it was the case of the complainant, through his own evidence, as also the evidence of his character witnesses, that he was a man of impeccable reputation. We challenged that, we contested that, and we said that this claim is false, because this incident of sexual harassment was not limited only to Priya Ramani. In fact, 20 women had complained against him. And so we produced defense witness number 3, our third and last witness, an incredibly brave woman who had also gone through a very, very painful account of sexual violence, sexual harassment, sexual assault at the hands of the complainant. She came and testified in court, giving details of that incident. That incident did not corroborate Ramani's version. In fact, the two of them didn't work together at the same time in the newspaper. They worked a few years apart. And once he believed that DW1 and DW3 were speaking the truth, the exception pleaded by Priya Ramani, and the court went a step further and said that given the fact that I believe the evidence of DW1 and DW3, I cannot come to the conclusion that the complainant is a man of stellar reputation. This, in a sense, was the structure of the Ramani trial. Now, the Me Too movement and other such movements has been criticized on the ground that anyone can call out anybody. What defense does a man have in such a situation? To some extent, as an officer of the law, I agree. And I believe that you cannot put a man defenseless in such a situation. Anyone who believes in due process, anyone who believes in the constitutional principles of Articles 20 that laid down in Articles 21 will have to take into account the fact that in such a situation, a man is largely defenseless. But why do movements like Me Too get the kind of traction that they got in America and in India? To some extent, it's because our legal system has failed women. And that is a recognition that we need to make. Our legal system has failed women who have been raped. Our legal system has failed women who have been sexually harassed at the workplace or have been sexually assaulted. It is very easy to tell women to go file FIRs. And I've consistently said that if any one of you is asked to defend an accident case, I'd like to see the kind of pressures it will put on you. Filing a case in a court of law and pursuing it is one of the toughest things that a human being gets to do. And for women, it becomes even more tough because they face a hostile system. As a woman who's both a prosecuting counsel as well as a defense counsel, I have seen the brutality with which women survivors are treated in court, the brutality with which she is cross-examined endlessly. As we speak, I know of a case where a woman was cross-examined for over 120 hours at a stretch, 770 pages of cross-examination in a rape case. What kind of system permits this? And why is this allowed? So in the context of defamation, free speech, due process, are we being fair to the women? Is a question we need to ask. And why do movements like the Me Too movement, why do they get the kind of traction that they got in India and elsewhere? I believe one of the reasons it got that traction was because it gave women a safe platform to call out their male bosses without accessing the legal system, because the legal system had failed them. Never forget, Vishaka as a judgment, iconic as it was pronounced by the Supreme Court because of one woman and her tragic case of failing within the judicial system. That woman was Bhavari Devi, a woman of a lower caste who blamed upper caste men for harassing her. She lost the case. Her appeal is still pending in the Rajasthan High Court. The Vishaka Guidelines and the Sexual Harassment at the Workplace Prevention and Prohibition Act of 2013 was the consequence of the struggle of Bhavari Devi and the collective struggle of hundreds of women in this country who wanted equality at the workplace, who wanted safety at the workplace. Now, when this is our system, can you blame women for accessing a platform which is outside the legal framework? Would they have done so if the legal framework had given them instant, robust justice? That's a question all of us need to ask. And in that context, I would like to read out what the witnesses in the Ramani trial had to say with respect to the Me Too movement. Ramani herself said in her 313 statement, in October 2017, the Me Too movement in America emboldened countless women to break their silence and share their experiences of sexual harassment at the workplace. In this context, I wrote an article for the Vogue magazine addressed to and titled, within quotes, to the Harvey Weinsteins of the world, unquote, where I spoke about many women's experiences with many male bosses. I began the article with my sexual harassment experience, but I did not name the complainant. 1 year later, when the Me Too movement came to India, and many women in my industry, media, started speaking up about their stories of sexual harassment, I felt as a senior journalist a responsibility to remove the cloak of anonymity. I decided to name the editor in that Vogue article. I spoke the truth in the public interest and in the context of the Me Too movement. I finally had the courage and the platform to name the complainant publicly. The complainant has filed a false case against me. He has deliberately targeted me to divert attention away from serious complaints against him. Through his testimony, he feigned ignorance about my story and my truth. It is unfortunate that women who had experienced sexual harassment at the workplace must now defend themselves in criminal proceedings for speaking the truth. Likewise, when she appeared as a witness subsequently, she stated, I spoke the truth when I disclosed my experience of my first job interview in the Vogue magazine and in my tweet dated 8/10/2018. It was important and necessary for women to speak up about sexual harassment at the workplace. Many of us are brought up to believe that silence is a virtue. In all my disclosures pertaining to the complainant, I spoke the truth in public interest and for public good. It was my hope that the disclosures that were part of the Me Too movement would empower women to speak up and to better understand their rights in the workplace. This case has come at a great personal cost to me. I have nothing to gain from it. I am well regarded and a respected journalist. I live a quiet life with my family in Bangalore. It is not easy for any women to make such disclosures. By keeping silent, I could have avoided the subsequent targeting. But that would not have been the right thing to do. Likewise, defense witness number 3, who also came to support Priya in this journey of criminal defamation complaint against her, said the following: I was 26 years old. I was alone, confused, helpless, and most importantly, petrified. Asian Age had no mechanisms to listen to complaints of sexual harassment. There were no internal redressal mechanisms, no sexual harassment policy or committee that would hear complaints from women journalists. I was on my own. Not only was he the editor-in-chief of the Asian Age, he had also been a member of parliament. I believed then that going public about my complaint or even thinking about the police was not an option, given his power and clout. In any case, the workplace in 1997 was very different from the workplace today. Women journalists were not encouraged to complain about their male colleagues or bosses. These are the stories of women who suffered harassment, grievous harassment, assault, and yet was sought to be silenced by the filing of a criminal defamation case only because they used the Me Too platform to call out their male bosses, only because they used the Me Too platform to write articles, to make disclosures about something that had happened 2 decades ago, but they felt they needed to say it to correct a grievous wrong that had taken place 2 decades before the 2013 Act had come into place. It is also important to speak truth to power. Men holding high positions of power who hold those positions with impunity, who act with impunity, who treat women in this grievously offensive fashion, need to be called out. And that is the only way that there can be complete empowerment in our society. So when you look at defamation, and when you look at criminal defamation, you have to look at it from all these angles, not from the prism, the simplistic prism of whether the imputation has harmed the reputation of an individual. What about the reputation and the harm caused to the women through your actions of sexual harassment? What about the harm caused? And this harm has a lasting effect on them, and which is why they are recalling it 20 years later. So through the Ramani trial, we were able to establish 3 things. One, that she spoke the truth. We could not have established that unless she took the stand and unless she gave details of the incident of that night in the hotel room in 1993. We were able to bring on record corroborative evidence in the form of WhatsApp messages between her and her corroborative witness, defense witness number 2. And we were able to produce another witness who spoke of her own story, unrelated to Priya's story, in order to buttress the claim of the complainant that he was a man of stellar reputation. It was one of our defenses in trial that by filing this criminal defamation case against Priya Ramani, the complainant had sought to weaponize defamation, because the effect of this was to create a chilling atmosphere, a chilling effect, which would have a rippling effect amongst other women. The filing of this case resulted in the silencing of women. And therefore, it created a chilling effect on the disclosures that women were making at that time against a person who, it seemed, had employed these tactics with women with impunity. To free speech be weaponized in such a manner is a question we need to ask, which is not strictly a question which we need to see within the four corners of 19.2. It is not a question that we can strictly see within the four corners of the judgment of the Supreme Court, which has upheld criminal defamation as being constitutional. We need to revisit these because, and also in the context of the fact that many countries across the world have done away with criminal defamation, although civil defamation continues to be employed in most of these countries. Is it time for us to revisit the 2017 judgment in Subramaniam Swamy? Is it time for us to take away criminal defamation from the statute book? Isn't it sufficient if we have civil defamation or libel? Should we penalize someone for free speech? Is a question that needs, I believe, to be revisited and revisited soon. So this really was the structure of the Ramani Trial. Harper versus State of Madras, 1950 SCR 594, it was held that thus very narrow and stringent limits have been set to permissible legislative abridgment of the right of free speech and expression. And this was doubtless due to the realization that freedom of speech and of the press lay at the foundation of all democratic organizations, for without free political discussion, no public education, essential for proper functioning of the processes of popular government, is possible. A freedom of such amplitude might involve risk of abuse. But the framers of the Constitution well have reflected, with Madison, who was the leading spirit in the preparation of the First Amendment of the Federal Constitution, that it is better to leave a few of its noxious branches to their luxuriant growth than by pruning them away to injure the vigor of those yielding the proper fruits. Likewise, in Shreya Singhal versus Union of India, 2015, Volume 5, SCC 1, it has been held, and I quote, various judgments of this court have referred to the importance of freedom of speech and expression, both from the point of view of the liberty of the individual and from the point of view of our democratic form of government. For example, in the early case of Ramesh Thapar versus State of Madras, SCR page 602, this court stated that freedom of speech lay at the foundation of all democratic organizations. In Sakal Papers, Private Limited versus Union of India, 1962, Volume 3, SCR 842, a constitution bench of this court said that freedom of speech and expression of opinion is of paramount importance under a democratic constitution which envisages changes in the composition of legislatures and governments and must be preserved. You will, of course, look at the Ramani trial in the context of the Vishaka judgment of 1997, where the Supreme Court held that the absence of enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment in the workplace, guidelines had to be laid down. The judgment specified norms and guidelines to be followed in all workplaces or other institutions until a legislation could be enacted. In Vishaka, it was held that the fundamental right to carry on any occupation, trade, or profession depends on the availability of a safe working environment. Right to life means life with dignity. Para 3 recognized that gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized basic human right. The common minimum requirement of this right has received global importance. So Vishaka recognized the right to dignity and the right to a safe work environment as a constitutional right. In the light of that, if a woman was making disclosures about the harassment she faced at a time when there was no law occupying the space, no Vishaka, could she have been prosecuted for criminal defamation is also a question that we need to ask. 2 years after Vishaka, in Apparel Expert Promotion Council versus A.K. Chopra, 1999, Volume 1, SCC, page 759, the Supreme Court said, an analysis of the above definition shows that sexual harassment is a form of sex discrimination projected through unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct with sexual overtones, whether directly or by implication, particularly when submission to or rejection of such a conduct by female employees was capable of being used for effecting the employment of the female employee and unreasonably interfering with her work performance, and had the effect of creating an intimidating or hostile work environment. In Medha Kotwal, Lele and others versus Union of India and others, 2013, Volume 1, SCC 297, it was observed that the Vishaka judgment came on 13/8/1997. Yet 15 years after the guidelines were laid down by this court for prevention and redressal of sexual harassment and their due compliance under Article 141 of the Constitution of India, until such time appropriate legislation was enacted by Parliament, many women still struggle to have their most basic rights protected at workplaces. The statutory law is not in place. The Protection of Women Against Sexual Harassment at Workplace Bill 2010 is still pending in Parliament through Lok Sabha, though Lok Sabha is set to have passed that bill in the first week of September 2012. The belief of the Constitution framers in fairness and justice for women is yet to be fully achieved at the work. Finally, the Act was passed in 2013 after some prodding from the Supreme Court. But the Supreme Court itself, like other institutions, were not compliant with the Vishaka guidelines and the 2013 Act. And so a petition was filed in the Supreme Court called Binu Tamta versus Union of India in 2015. And it was pursuant to that petition that was filed by certain advocates on record in the Supreme Court that the Supreme Court itself framed guidelines for an in-house mechanism to deal with sexual harassment within the precincts of the Supreme Court. Pursuant to that, many high courts, including the Delhi High Court, also framed their own guidelines. So courts themselves were not compliant till about 2015, 2016. And the judgment of the Supreme Court was not followed within the precincts of the Supreme Court. And it was only after Binu Tamta's case that the Supreme Court framed guidelines for purposes of dealing with sexual harassment within the precincts of the Supreme Court. Now, as a consequence of these disclosures made on the Me Too platform, I will argue that there has been a fair degree of pushback faced by those who speak freely. While the law evolved in response to people's movements and sustained academic and judicial engagement, the failure of courts to address sexual harassment and violence against women is evident in the way in which survivors of sexual violence are treated in courts and the language employed in these cases. This continues till date. In a recent judgment, a man was acquitted of rape because the quality of the woman's consent was deemed to be a feeble no. In practice, the cross-examination that victim survivors of sexual violence are subjected to continues to be brutal and violent despite the evolution of the law. In a recent case, a rape victim was asked, I'm anonymizing the case and I'm anonymizing some of these questions, but this is the text of some of these questions. Have sex with another person, is it an objectionable act? How many times has she had consensual sex, and whether she had more consensual sexual experiences outside her marriage, which the court did not record. Is it immoral to have consensual sex with different persons? These are the kind of questions survivors of rape are being asked today in courts, in cases that are pending. And then we say, why don't women complain? Why don't women access the legal system? Who wants to go through this? Who wants to be humiliated in this fashion? The victim was further confronted with a large number of private messages between her and her friends. On each day to cross-examination, the victim was requested to sit for hours on end, as her own messages relating to a period much before the incident in question were displayed to her. The cross-examination being conducted on behalf of the accused appeared to be designed to humiliate, shame, and exhaust her, both physically and mentally. Additionally, we have seen that provisions meant to protect women, survivors of rape, are being used by the accused in several cases to prevent fair reporting on rape trials. Section 327(2) of the Code of Criminal Procedure mandates that rape inquiries and trials should be conducted in camera. Section 327(3) mandates that it is unlawful to print or publish any matter related to in-camera proceedings without the court's previous permission. These legal provisions were introduced in India with the intention of safeguarding the identity and the privacy of survivors in a patriarchal society that can react adversely to women who have faced sexual assault and harassment. But it has been recently reported in various outlets that a prominent Malayali film industry actor accused in a rape case has obtained a gag order from the trial court, putting a complete ban on media coverage of the trial. There is a growing trend towards obtaining injunctions or media gag orders by powerful accused in cases of rape or sexual harassment, ostensibly in order to protect their own reputations. The use of provisions intended to protect rape victims by the accused for their own benefits and ulterior motives must therefore be guarded against. Faced with systems that are unable to provide justice, redressal, and that continue to function without sensitivity and care, women and some men have, in an unprecedented wave of disclosures, taken to social media to name those who have harassed them in the past. In response to these disclosures, many women and some men across the world saw the use of defamation lawsuits being brought upon them. The use of the law to silence those speaking in the public interest has been referred to as SLAPP suits, or strategic lawsuit against public participation in various jurisdictions. And several have made laws specifically designed to restrict such lawsuits, including in several states in the United States of America, in Australia, and in Canada. While India has no such law, certain judicial pronouncements have noted this phenomenon. In Messrs. Crop Care Federation of India versus Rajasthan Patrika Private Limited, a civil defamation claim, the High Court of Delhi, speaking through Justice Ravinder Bhatt, held that the present suit contains all the ingredients of a SLAPP suit. A strategic lawsuit against public participation is a lawsuit intended to censor, intimidate, and silence critics by burdening them with the cost of a legal defense until they abandon their criticism or opposition. Winning the lawsuit is not necessarily the intent of the person filing the SLAPP. In such instances, the plaintiff's goals are accomplished if the defendant succumbs to fear, intimidation, mounting legal costs, or simple exhaustion and abandons the criticism. A SLAPP may also intimidate others from participating in the debate. Coined in the 1980s by the University of Denver professor Penelope Cannon and George W. Action or outcome which resulted in a civil complaint or counterclaim filed against non-governmental individuals or organizations on a substantive issue of some public interest or social significance. It has since been